And what is the income of the husband?
Husband, I have filed my ITR, which is about 6 lakhs, your lordships.
6 lakhs per annum.
Per annum.
Per month.
Per annum. And wife earns about 82 lakhs per annum. As of 82 lakhs.
And the court is granting such an exorbitant amount as educational expenses and also 20,000 as maintenance. The court has to discuss what is the financial status of both the parties. Without doing it, what is this
Yes,
order?
they did not even file objections for my application.
Where have you filed? Where is your financial capacity is discussed by the court? You will put a child in a school where the school expenses are 2 lakhs. Then where?
7/3/2025, I have produced the entire school expenses.
That the court has to determine. Just like that, we cannot direct. We can't direct the court.
I'm challenging the order passed in GNWC 175 of 2017, wherein the learned judge directed the petitioner father to pay the entire school fees in its entirety.
Come to the impugned order.
Impugned order is at page number 18, your lordships.
80.
In page number 18. While filing the one more issue that I would.
Not 80.
18, your lordships.
18.
18.
Petitioner husband is hereby directed to pay the educational expenses of the minor child. Day one of the educational career of the son. Subject to producing the receipt of bills of the school to the satisfaction of the petitioner. Apart from also directed to pay the maintenance expenses of 20. What are the school expenses?
School expenses comes up to 12 lakhs.
Per annum.
Overall. While at the time of filing the application, it was
Per annum, how much it is?
per annum. Now it has gone up to 2.5 lakhs, 2 lakhs, around between 2 to 2.5 lakhs.
2.5 lakhs.
Yes.
Now if the arrears have to be paid, they are 12 lakhs.
12 lakhs is what they've claimed.
And what is the income of the husband?
Husband, I have filed my ITR, which is about 6 lakhs, your lordships. And wife earns about, as of 2022.
6 lakhs per annum.
Per annum.
Per month.
Per annum. And wife earns about 82 lakhs per annum. As on 82 lakhs.
Please come to the order.
At paragraph number 7, she has stated in her application,
Please read.
may I bring your lordship's attention to page number 100, the application.
Read the order and go to
Order,
the-
yes.
Yes.
From the top, your lordships.
Yes. From page number 20. Paragraph number 7.
The petitioner is the husband of the applicant respondent. Filed the application under section 7, 9, 10, 11 and 12 of the Guardians and Wards Act, thereby seeking custody of the minor child, Master Ryan, of till attain the age of majority. So it could be held that the minor child is now definitely in the custody of the respondent mother. It is stated by the petitioner that the petitioner married the respondent on so and so date as per the traditions. It is also stated that the petitioner, in the said matrimonial life, the respondent had conceived and gave birth to the child, boy baby, on 21.
Where is the discussion about the financial capacity of
No, assets and liability was not filed at all, your lordships. And another issue is that I had filed IA number 7, seeking visitation rights.
1 minute. Okay, what do you say? What is this order?
Assets and liabilities were not filed before the family court, please, Millards. Plus, it was filed on 27/2/2019, please, Millards. These two applications I have made. I had filed these.
When the court is granting such an exorbitant amount as educational expenses and also 20,000 as maintenance, the court has to discuss what is the financial status of both the parties. Without doing it, what is this
Yes,
order?
they did not even file objections for my application.
Where have you filed? Where is your financial capacity is discussed by the court?
Millards, in para 8.
Yes,
Let's-
read para 8.
On the other hand, the applicant respondent took the contention that the petitioner had deserted her and her child and did not provide anything to their livelihood, apart from it towards meeting the education expenses of the child, Master Ryan. The petitioner fails to object the said contentions taken by the respondent in the application. When there is no dispute with respect to relationship is concerned, apart from when there is no dispute to the born of the child in the said matrimonial
Read the entire
relationship.
paragraph.
Yes.
That paragraph is on something. When the court is granting maintenance without discussing about their financial aspects, if he has not filed the statement of assets and liabilities, court should have recorded it that he has not filed.
No,
Has she filed?
Well, in GNWC, he did not file assets and
Has
liabilities.
she filed?
No, Millards.
Then how the court will decide?
In DV proceedings, we have filed.
What is her income per month?
No, we have not sought for any maintenance for wife.
Not about
No,
wife.
for
I'm
child.
asking, I'm asking what is the salary of the mother?
As of now, she is unemployed. She is removed from the company business. Now the company, the employer,
Who is earning 82 lakhs per annum?
no, my less, he is saying false.
No, the same document.
No, ask your client that what was her before being
Last salary,
removed?
last paid.
Last paid salary,
salary.
what is it?
Last paid salary.
May I make one submission?
1 minute.
Per month. 4.5 lakhs per month.
And when is she removed from service?
Less.
When is she out of employment? From when?
Last 2 months. Last 2 months.
Why? What happened?
That the project, I think, the employer has removed.
Yes. No, when is this petition filed? When is this impugned order? This impugned order is passed on, what is the date of the impugned order?
Date of
Millets, wherever she was working.
20
The husband.
26
No,
26 September 2022.
We'll go into that. 26
In fact, he is the main
September.
cause for removal of her
That
from the
will
employment.
go into.
Please, please.
No, 26/8/2022, she filed she got this order.
Yes, please.
How much maintenance she sought for the child?
Millets, applications.
She wanted 12,14,870
Yes,
and
please.
20,000 towards maintenance of the child.
Yes.
Her salary is 4 lakh, what did you say? 4 lakh?
4,50,000 around.
4,50,000. And where did she assert about the husband's income?
Millets, Millets, I'll please.
Where did she say?
Millets, kindly see my statement of objections, please, Millets.
Yes.
Annexure R9, please, Millets.
The volume number, sir.
Volume, no, only one volume. Statement of, that is.
Yes.
Annexure R9, Millets, he does not produce latest bank account statement, latest ITR returns, nothing.
Actually, we'll
Then
find out. I
we-
asked you a
we-
question.
Millets.
According to you, what is the salary of the husband?
Yes, please, Millets. We were constrained to file an application under section 91 of CRPC.
But you can tell
So
me the-
based on that, this account
What
statement
is
was
that?
called
What
for
it says?
Millets.
What it says?
Please, Millets. He has got 1 crore 53 lakhs at a stretch. Millets, can you kindly see page number 253. 253 of my statement of objections. He is a software engineer, please, Millets. On 12th December 2024.
That is one aspect. What is his salary as per this?
He does not produce any salary slip, please, Millets. He is working as software engineer.
Said, some information you have obtained under right to information. What
No,
information?
not under right to information, please, Millets. This statement of account pertains to petitioner was called by the.
I will set aside this order and the family court decide all this by taking the assets and liabilities.
No, Millets.
And let him pay the 10,000. We will see about the 20,000. We'll see about now in the change of circumstances.
Millets, as per
Whatever
the interim order passed by this honorable court, he has deposited at the rate of 10,000 per month. But he has not at all paid education expenses.
Not 10,000. Let him pay 20,000 per month.
No.
But
No, let him pay,
educational.
let him pay 10,000, please, Millets. But let him pay 50% of the entire education expenses. I have produced the entire documents, education expenses,
No.
school receipt.
For example, his salary is 6 lakhs. You will put a child in a school where the school expenses are 2 lakhs. Then
On
where-
7/3/2025, I have produced the entire school receipts.
For that, the court has to determine. Just like that, we cannot direct. We can't direct the court.
Let him pay 10,000 per month. And let him pay 50% of it. On 7/3/2025, I have produced the entire receipts.
Whether joining a boy in the particular school, have you consulted the father?
He is settled in Germany with his second wife.
That's what they've been
Now-
saying, your lordships.
And-
They've been,
Let's kindly see.
from the inception, they've made unscathing and unwarranted allegations
Let's
against the
kindly see
petitioner.
this order, which is passed by the GE court.
Even as we speak, there are 8 pending proceedings between the parties.
I had made an application to call for his passport to ascertain his travel details, please. There are 6 of this order, please. There are 6, please. Perusal of the record reveals that the respondent has filed his bank statement only till
Where are you reading
2014.
that?
There are 6 of this order.
This order has only para 5. There is no 6.
So it is.
New one. Which one did you do?
Yes.
Which side?
Why you are not filing the documents before
Your
the
lordships,
court?
whatever document that I could obtain from the petitioner that I have already filed. And
Not
I've
about
also
you could-
filed my ITR.
Not about you could obtain. Petitioner has a duty to give those documents to you.
Bank statements I have produced, your lordships. I have given to them already.
Then what
And
is
also
this order?
ITR.
Have you questioned this order? That's passed.
No,
by
I
the
intend to
court.
question that order, your lordship.
Which is where- when
Which
is
was
it filed?
recently, last month, it was passed last month.
Anyhow, now without going into all this, as it is the order that's passed by the court, without any basis, without any reasoning. These kind of orders cannot be sustained. This is not the way the orders have to be
2.5
passed.
years, he did not file even
Please
objection.
understand, Mr. Counsel, we are not on the facts of the case. We are not about what is happening between the parties.
Please.
I'm only concerned with the impugned order. Impugned order is bereft of reasons. Nothing, no exercise is done by the court. And I can understand a school fees of 10,000, 50,000, 40,000, something court has granted. It is running into lakhs of rupees. Court first should have seen what is the capacity of the mother, what is the capacity of the father, isn't it? Then proportionately, there should be contribution. And first of all, for example, for husband's salary is 2 lakhs, wife's salary is 4 lakhs, why should it be 50-50%?
He is not revealing at all about his.
That is the other aspect. That's what I'm saying. And we are not going into all that. This impugned order cannot be sustained for the reason that the court has not considered any aspects while granting such exorbitant amounts. Let him pay 20,000 till.
20,000 will be very difficult for
Why?
him. 10,000 he can, I've been paying 10,000. I don't mind
Not
paying
voluntarily,
10,000.
please.
But 20,000 is, your lordships, even,
Not voluntary.
Come. Agreed with orders passed in. I number. What is this IA pertaining IA number 8 and 9?
IA 8 is with respect to school fees and IA 9 is with respect to paying maintenance at 20,000 rupees. And one more submission, your lordship. I had filed IA number 7 for visitation of rights, seeking visitation of rights. That is still pending even to this day. I had addressed my argument with
What do you
respect
do
to.
with that? Now, we can't decide everything on something else.
No, but direct,
You should have asked, no, we'll not
Well,
pass
that's
any direction.
3
Your
years
lordships,
back,
I've been-
he was
Orders
I've been-
passed in I number 8 and 9 in GNWC
He did
number
not press that application.
117,
I've been pressing the application.
2017, dated 26/9/2022, whereby the court had granted whereby the court had directed the father to pay the entire educational expenses of the child and also directed to pay maintenance of an amount of 20,000 per month regularly until further orders. The respondent mother has filed her application 8 and 9. One is to pay the amount of rupees 12,14,870 and the other is for 20,000 per month as maintenance. The court had directed the father to pay and this court has perused the order that is passed by the court, except stating that it is the responsibility of the father to take care of the child. Nothing has been stated by nothing has been discussed by the court. Court has failed to discuss about the financial capacity of the father, the financial capacity of the mother. Land counsel for the petition submits that the mother is earning 4.5 lakhs per month and his salary is?
His salary is 6 lakhs per annum, your lordship.
His salary is 6 lakhs per annum.
Last.
And the court, without considering all these, had passed the order.
That is last paid, sir.
I will, that is his contention.
No contention.
Oh, I'll record your contention also.
Please, please.
Land counsel appearing for the respondent submits that from the last 2 months, she's out of the job. And it is because of the acts, it is because of the acts of the husband, of the father. It is submitted that now she is unemployed. Next one. Having heard the counsels on both the sides, there is the material on record. This order is passed in the year 2022. In the year 2022, the mother's income is 4.5 lakhs per month. And she is seeking 20,000 maintenance to the child and asking the entire educational expenses to be paid by the father. When such an application is filed, court ought to have considered what is the income of the father, what is the income of the mother, and what should be the contribution of both the parties to the child. The court has failed to consider any of these aspects and simply considering the fact that he is the father and he has the responsibility, had directed the father to pay the amount. The said order cannot be sustained, and in fact, the court had failed to follow the guidelines issued by the apex court in Rashish versus Neha. In that view of the matter, this court feels that the order of the court as far as granting the educational expenses needs to be set aside, whereas the amount of 20,000 that is ordered by the court shall be, this court do not find any reasons to interfere. Accordingly, the court is passing the following order. The order dated so and so is set aside. As far as the educational expenses are set aside, and the matter is remanded back to the trial court. Within 1 month from the date of receipt of the copy of the order, both the parties shall file their statement of respective statements of assets and liabilities as envisaged with the Honorable Apex Court in Rashish versus Neha, and within 1 month from there, the court shall decide the application. As far as 20,000 is concerned, the petitioner shall continue to pay 20,000, even if the arrears are there. The arrears also
4 months arrears, sir.
shall be paid within a period of 8 weeks.
Your Lordship, 20,000 may be reduced to.
In the year 2020.
It is submitted that in the year 2022, when the order is passed, she drawing 2 lakhs, and at present, before the last pay, before she lost the job is 4.5 lakhs.
Your
Yes.
Lordship, 20,000 may be reduced to 10,000.
And
And you may make one more submission, Your Lordships. IA number 7 may be disposed along with IA number 8 and
Come
9.
up with the petition, then we will see.